Griffith, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate it very much. This is an important hearing because it points out some major flaws and problems that we have in the way that Washington is currently working. I think it's high time. Classic example of it. It's high time we start defending the legislative prerogative. It's not a matter of Democrat or Republican or independent or socialist or whatever party you want to put on there. It's a matter of defending the Constitution from the congressional branch, the legislative branch of our government. We aren't doing it, and we should be doing it, whether it's Democrats or Republicans, as I said. And it's one of the reasons I really hope we'll have a Republican president, so that my colleagues on the other side of the aisle will see that if a Republican president were to flaunt the law as it has been flaunted in this particular circumstance and try to spend money not authorized by Congress, I will stand up and say to that president, just as I'm going to say today, you can't do that, and we're not going to sit idly by and allow you to do that. Doesn't matter whether it's a Republican or a Democrat, whether it's a program I like or dislike, we've got to follow the law. Just yesterday, we are not robots here, just doing things. Yesterday, I made an independent constitutional decision. We don't have to wait on the courts to tell us what is and isn't constitutional. We get to make some of those decisions ourselves. That's why we take an oath to uphold the Constitution. And I voted against a rule against my party because I thought paragraph 5 of the rule included something that I believe is unconstitutional. Now, all that getting off my chest, I have to say this as well. I think the 60-vote rule in the Senate is killing us. Mr. Lazarus, you said it's easy for us. We can just pass a law. We can in the House pass a law with a majority vote. You can't do that in the Senate. They've totally botched up the entire process. Again, doesn't matter whether you're a Democrat or a Republican. When it takes 60 of 100 votes to pass a piece of legislation, it's wrong. The process doesn't work, and it is weakening the legislative branch of government and is dangerous to the Republic. Mr. Rosenberg, you said to Mr. McKinley, if this ruling is upheld and we now have to flip things around, voting for appropriations, we have to vote against appropriations and say you can't spend money here. The problem with just passing a law and having a new plan is that 60-vote rule in the Senate. There. I got all that off my chest, but I think it's very clear, just like in the Solyndra case where they didn't have authority to subrogate, then they subrogated and claimed that, before lunch was different than after lunch because it was, an hour later you could subrogate because you weren't supposed to subrogate at the time of the initial loan, but you could come back later. It's the same kind of thing here. They're interpreting the law in such a way. And when we take the position as a legislative branch of government that we have to sit back and wait for the courts before we can take any action, we lose our authority and it diminishes the legislative branch. Mr. Rosenberg, would you disagree with what I've just said?
Not at all.
And I appreciate that. Mr. Miller, would you disagree with what I've just said?
No, and I would just underscore that what was unique about the House v. Burwell case is we need to think about this. The judge knocked out a different complaint that the House had about the employer mandate because that was a matter of statutory interpretation. However, this went to a core constitutional provision, the power of Congress to determine appropriations and spend money. And that's why it was uniquely moved forward and got past the standing considerations. There was really no other plaintiff you could have bring this case before a court. And that's why the judge, in a very unusual ruling, said this is the only way to remedy this issue.
And I think we may have some more of those, but first we have to, stop looking at ourselves as playing for the Republican team or the Democrat team and start playing for the legislative branch of government, because if we follow the process in the legislative branch of government, we will end up with better government. I don't think that, in due deference, Mr. Lazarus, I don't think that we can say we can flip it. I think that's bad for the Republic too, where you say that since we didn't specifically say they couldn't spend it, can spend it. I think that's an error for the...
Mr. Griffith, if I could just add one thing you didn't mention. Beyond the 60 votes in the Senate, you've got a presidential veto. So you have an administration which could act illegally and then protect its illegal actions by vetoing correction by Congress to try to override it.
Well, and that's true, although I respect the constitutional prerogative of the president to veto a bill, but at least if we could get it out of the Senate, we'd make him veto it, because my position is the president won't veto everything you send him. If we send him 70 bills he doesn't like, we're going to get 10 or 15 of them at least past that veto pen. My time is almost up. Mr. Rosenberg, I'd love to get the cites on that Teapot Dome case that you cited earlier, because I think that's important, again, as a part of a legislative prerogative. And that's really what this hearing is about. It's not about trying to take down the ACA. It's about the legislature defending its right to determine where it's going to spend money and where it's not going to spend money. And unfortunately, the administration has totally disregarded it, and we need to be more aggressive. My time is up, so unfortunately I can't let you respond.
In my testimony on page 5.
On page 5, all right, very good. And I yield back, Mr. Chairman.